Welcome to Saunders on Security, brought to you by Corinium Global Intelligence. This is the podcast for busy CISOs talking about security and all things security related. And today I'm very happy to have with me David Luyt from Michalsons Attorneys down in Cape Town. David, good to have you on the podcast. Tell us a little bit about yourself. What are your passions? What got you into this space?
Hi there, Ross. Thanks very much for having me on. So I sort of ended up in this space by happy accident. I always say I'm a recovering litigation attorney. So I started out with a very traditional route to law. I got my articles, ended up on a panel of attorneys that did bank foreclosures, went to higher court and did some necessary but arguably evil work of making sure that people who didn't pay their mortgages had consequences come to them. And during that course, during the course of my candidacy there, I met another nerd, as I like to say. Shout out to Nicholas Hall, who got me into Michalsons. And yeah, I've never looked back ever since, and ended up in Michalsons, where we specialize in IT and data protection law. And yeah, I'm a nerd lawyer. That's how I ended up here.
Fantastic. Yeah, I know Nick well, so he can be persuasive.
Friend of ours. He's a good talker.
Cool. I mean, so within the space, you interact, I'm sure, with a bunch of CISOs and things like that. What is sort of the security and privacy landscape that you operate in? Where do you see your start and finish coming in?
Sure, yeah. I sort of live in two worlds, and I always say I believe in the power of liminal spaces, and I am a crossover between the legal compliance side and the technical side. And if anything, I'm definitely more on the legal compliance side, but it's the interface between the two. So I get involved a lot in helping people interpret InfoSec standards, helping them interpret information security laws, determining how they limit their liability and things like that. And I draft a lot of agreements and contracts and policies. I do a lot of training and presentations on the basis of that. So yeah, definitely more on the paper pen pushing side. But I always say, I'll leave it to the developers out there to write code. I write the code that programs human relationships, which is, if it gets, there's no one compiler for it, which gives you some leeway. But yeah, I program legal relationships essentially.
Fantastic. I love that. And you mentioned talking about agreements there and paper, and that is pretty much exactly what we're going to be talking about today. We're going to be talking about information security and also data processing agreements, because we are seeing so many of those flying around. I think with GDPR having come in 2 years ago, or 2.5 years ago now, time is flying under lockdown, and PAPIA being signed in July, we're starting to see a focus on these data processing agreements, and I'm seeing a lot of them flying around with my clients. So David, what exactly is a data processing agreement?
So a data processing agreement is really all built into the name there. It's a legal contract between two entities. In the South African context, we talk about a responsible party and an operator. Internationally, it would be a controller and a processor, sort of different terminology for the same things. And then it governs how you process data. So data and information are often synonymous in the data protection world. I would say information is often data that people care about, but broadly speaking, data is kind of the more international term. And then it's how you process it. So how you take it in, combine it with other data, put it out, anything you're doing with it. And for me, it always hinges on this idea that no organization is an island. We always work together with other organizations to process data. So it's really the salient document for regulating a data processing relationship. So any situation where you work with someone else to process data of data subjects, you would have a data processing agreement. And in terms of relevant data protection laws like the GDPR and even PAPIA, they are required to some extent. The actual content of them varies from law to law, but you can't get away without them. And yeah, it's causing a lot of consternation for people who are being asked to sign them and maybe don't know what they are or don't really understand them. But yeah, hopefully we can demystify some of those things today.
Yeah, I hope so. I mean, I've seen some, and you speak about them being a range, depending on the laws and stuff. I've seen some of them that are in dozens and dozens and dozens of pages worth of information, and some that are a lot shorter, and some that are straddled between two different laws and things like that. So if we have to look at these kind of agreements, and I mean, I think they're very, very valuable in that I suppose it takes away a lot of the confusion that might go on. What do you feel is the significance of having these documents in place and putting this kind of agreement in
Yeah.
mix?
So look, the temptation is always to focus on the stick. You have to have these to some extent, but I think it's also important to bear the carrot in mind. And, you know, as you said, they do have a lot of value and they create some certainty, so, absolutely. And they account for eventualities that you maybe haven't planned of. So, I mean, classic things that'll go into them. And, you know, I'm conscious this is an InfoSec podcast. They contain a lot of different things, but a lot of their provisions are InfoSec related. But they deal with things like your information security policy. They operationalize that so it can exist between two entities, because normally it just applies to your organization. They have mechanisms dealing with breaches and how that gets reported. They also often create what we call the processing chain from a contractual perspective. So going back to this idea of no organization being an island, you know, you are a software as a service company, for example, you've got lots of suppliers going up the chain that provide you with everything from hosting to certain modules of your software that you sell onto the customer. There's no good you having a contract with one person in the chain if they don't have a back-to-back contract going all the way up to where the incidents, the breaches might happen. So they create that sort of value. So, you know, like so many legal contracts, when they're done well, they protect you from common pitfalls that a combination of the law and practice has shown exist in these relationships. When they're done badly, they exist to control and stifle people in the processing chain and push liability from one entity onto another. So it very much depends on your perspective, whether you're a controller, a processor, or indeed a sub-processor, as to, you know, how you're going to want to draft one of these agreements. And yeah, what you want from one, what you're going to get from one can be very different depending on the amount of contractual power you have in a situation as well. But yeah, so I hope that answers your question.
I suppose, I mean, correct me if I'm wrong, does it bring in a bit of a debate as to who gets there first to draw up the data processing agreement if you haven't got one in place?
Definitely, you know, and I always say, you know, from a processor's perspective, particularly, it's like a pair of handcuffs. You know, you could get a very spiky electrified pair that's going to make your life uncomfortable, or you could make a nice comfy pair that suits you well. And yeah, it's sort of incumbent advantage. The first person to draft it often benefits. Totally.
Can add a bit more protection in for yourself as opposed to.
Yes, yeah. I mean, that is another big issue with these things is they're not what we call high velocity agreements or high velocity contracts. So the classic example of a high velocity contract is something like a non-disclosure agreement or an NDA. You know, they've been around in the business world for so long, everyone knows what they contain. At some point in ancient history, these were a novel concept and they were all slightly different. Everyone was trying to put their own little provisions in there to protect themselves. You know, eventually DPAs, and they're fast becoming, you know, just you sign your NDA, you sign your DPA. It's just part and parcel of your relationship. They'll get to that sort of level of high velocity, but they're really not there yet, which is why they're all different and unique, and people are using them to protect themselves and give themselves advantages that they, strictly speaking, shouldn't be doing in that contract.
Yeah, I've seen a couple of places where the DPA is forcing a processor to basically become a controller in terms of data. It's been quite an interesting thing there. Do you ever see those two documents eventually merging into one, perhaps, the non-disclosure and the DPA? They do have their overlap now and then.
Yeah, it's interesting, and it's sort of, you know, you go to people, okay, you've got your SLA, you've got your your MSA, now you need an NDA, now you need a DPA. Like, I'm tired of acronyms. Can I just have it all rolled into one agreement? And, you know, arguably, yes, depends on the jurisdiction. So in South Africa under POPIA, for example, there's technically very little that has to go into a DPA, but you've also got to bear in mind where POPIA comes from. It's an older style data protection law. In many ways, it's been superseded by something like the GDPR. And I mean, Article 28 of the GDPR is a whole comprehensive shopping list of things that have to go into a DPA. And you try and put that into a master services agreement, an SLA, or even combine it with an NDA, you're going to have a gemors of a document that, you know, it kind of pulls in different directions. So I think it will get streamlined over time. We've seen some interesting things where, you know, the traditional way of signing an agreement is either some sort of hard copy form you literally print out and sign, or an electronic PDF that the parties e-sign. Some of the big cloud providers are doing online DPAs where it's just on their website and it's either incorporated by reference into their terms, or you can download it and sign it yourself if you want, but they're not going to sign it. And that kind of takes away a lot of the friction for agreeing to these things. So we might see, I'd say we'll probably sooner see it incorporated into online terms than sort of combined with an NDA. but it is possible. I just think it'll result in quite a messy agreement, because
Yeah.
an NDA is about confidential information, which is sort of more focused on the proprietary information rights of the business, whereas a DPA is very much focused on personal information, which is sort of more public right to privacy, the individual's right to determine what happens to their personal data. They pull in very different directions.
Yeah, and different data types, like you say. I mean, it is definitely an evolving thing. I mean, we're already seeing just right now, today, I'm seeing news articles about new recommendations for DPAs and stuff. So it is an evolving thing, but it's something we've seen a lot in Europe. And like you say, under Article 28, that there is a lot that we can use in there. You mentioned that POPI doesn't have it to that extent. What kind of things can we expect from these in South Africa?
Yeah, so it's interesting. If you look at POP here, it really requires two things of this written agreement. It says that you as the operator have got to follow the responsible party's instructions and implement reasonable information security. Now, if you just drafted an agreement like that, it seems nice and cushy for the operator, because they have very few obligations compared to their processor counterparts in Europe, but it actually doesn't really serve the relationship accurately. And there's a lot of stuff missing from that. It's almost a dysfunctional data processing relationship with just that in it.
Yeah.
On the other extreme, you've got what GDPR requires, right? Where it deals with all sorts of sticky issues, from like how I can come and audit you and check you're doing, what I say you're doing, how I have control for your sub-processes, how if you want to go and outsource data to anyone, arguably, or outsource a portion of your process to anyone, arguably you need specific permission from me to go to another provider. And like some people interpret that to be like the level of the name and the registration number of whoever you want to use to provide services to. Now, this is a lot of, me as a customer coming into your backyard as a service provider and telling you how to do business. It kind of grates quite strongly against some people. So it depends kind of who you're dealing with. So any sort of businesses in South Africa that have significant international exposure, a lot of their DPAs look a lot more like GDPR style DPAs. And whether you like it or not, that is kind of leading the world. And, as you said, Ross, there's so many developments happening right now. I mean, this is a constantly moving target. The Schrems 2 case, with Maximilian Schrems taking on Facebook through the Irish courts, and that going on to subsequent things, and ultimately really declaring, the new Privacy Shield system invalid and stuff like that. It's all in flux, so who knows where this is going to go. But I think probably what's happened at the moment is everyone's scared of the laws. They've turned it up to 11. They'll turn it down a little bit, as time comes. But we're definitely seeing the effects in South Africa. I'm seeing more and more South African style DPAs that they've just taken a GDPR version and swapped the word GDPR for POP here, really, which it kind of works, but not exactly.
Yeah, I've seen POPIA 2016-679, which was quite an interesting thing in a document.
Oh, that's fun. They made their own little chimera hybrid law.
So, I mean, you mentioned there that, the European one is dialing it up to 11. I mean, surely these create absolute massive restrictions on how you can do your business. But what's the wiggle room here? Can you argue them a bit? Where can you get some leeway?
Yeah, it depends on your jurisdiction, but I always like to talk about pain points, as in places where you're going to feel the pinch, often looking from the perspective of a processor or an operator. And I mean, the big ones are something like audit rights. The good news there is that all GDPR really says is that the agreement needs to deal with audits. It doesn't say who's got to pay for them, how they've got to be done. So something like that is there's a lot of wiggle room. On the incident reporting side, often you'll see a DPA that says you've got to tell me within 48 or 24 hours if you've had an incident, right? Now, to a certain extent, that time limit is arbitrary. If you look at GDPR, the time limit for reporting an incident is 72 hours. So a lot of people are saying, okay, well, I as the controller have 72, but I need to hear from you first. So I'm giving you a shorter time limit, so I have time. And that works fine if there's two people in the processing chain. But if you are entity number 7 in the processing chain, or let me be a little less extreme, number 3, then what are you going to do? Give 12 hours each and kind of divvy it up. Basically, it's a very literal interpretation of what GDPR says. So read GDPR properly. You need to report within 72 hours. If you take longer, you need to give reasons. And I think a good DPA is not going to necessarily enforce that time limit. It's rather going to explain how and why you need to report. Because in fact, if there's a big incident, I don't want I don't want to only hear about it 48 hours. I want to hear about it in that hour. I want to know that you've had it, but I'm not going to place a formal obligation on you to give me all the data and stuff like that. So I think it's a little bit more nuanced than people think of there. I mean, other places where there's a lot of wiggle room, from an information security side, really the GDPR's provisions on DPAs kind of linked to the information security provisions. And the good news there is there's this whole idea of TOMs, what they call technical and organizational measures. And that's really that you've just got to have reasonable safeguards to prevent access to personal data. It's not particularly prescriptive. I mean, GDPR mentions a few things. It mentions encryption, it mentions pseudonymization, but it's not going to come and tell you exactly what needs to happen there. So there's it's completely up to you to develop your own infosec policy from that perspective. If you're looking at GDPR there, so yeah, I'd say there's plenty of wiggle room if you know where to look. The unfortunate thing I've seen is a lot of controllers or responsible parties out there take the view that legal draft this agreement, sign it or go away, basically, and and I mean that is not a good way to do business, and also it betrays the fact sometimes these DPAs, they're not even suited for the situation they're working for. And as you said, you've seen situations where a operator's been basically made into the controller, by these DPAs. They are ultimately subservient to the law. Whether you're a controller or a process is a question of fact. You can't just change that in agreement. You can kind of formalize it and tweak a few things, and you can outsource and delegate some responsibility, but it's got to be done within the ambit of the law. But yeah, sorry, it's a long monologue, but
all good. No, I think I mean, you mentioned earlier software as a service and things like that, and I think that's also where you see a lot of that, I suppose, difficulty with the agreements. That's where I've seen a lot of the agreements that don't actually make sense for the context, in that something is now hosted here, but it's sub-processed at a hosting data center or in Azure or in AWS, and it becomes a very complex relationship that's not as easy to just boil down, I think.
Yeah, and look, I think a mistake a lot of people make when it comes to DPA is they just jump straight into signing a DPA, and that's like getting married and signing your ANC before you've got to know the person, met their parents, like had your first few fights, gone to some couples counseling, whatever. Like, I'm extending the analogy here, but really, you want to determine where your responsibility lies before you sign the DPA. Signing the DPA is not the time to decide who the controller and the process and the sub-processor are. You need to know that beforehand.
It's interesting you bring that back to antenuptial contract. That's exactly what I was thinking earlier. It's you want it in case of divorce as well, to see what's happening.
Exactly, yeah. So it's something, some terrible incident happens in the relationship, someone cheats on someone else, or, there's a catastrophic data breach and, thousands of records of personal data are leaked onto the dark web or whatever happens. Whose fault is it? So, yeah, that agreement helps you work that out.
So we mentioned a little while back, talking about the security safeguards and things like that. And I know on the European agreements, and if you've got the SCCs or if you've got DPAs, there's generally an appendix that starts in the agreement that starts speaking about information security. And you mentioned it's not really that prescriptive, but how do you see it affecting the information security? Does that become almost like a debate? I've seen a lot of it with, and I think it's every CISO's nightmare, is receiving that 72-page risk assessment, security assessment for controls. Yeah. But what do you think of that sort of arrangement there with the information security side?
So there's a few different levels here that people handle the InfoSec side. So the big cloud operators will just rely on an InfoSec standard. So they'll do something like get ISO 27001 certified. They'll get a SOC 2 certificate. And it's pretty common practice in a DPA to actually say, we're certified. And parties agree that this will be evidence of our information security compliance. So if you're at that level, you can often just hand that up. Someone tries to come to you with a checklist. You say, we've gone through this process. We picked one of the top InfoSec standards in the world and we're adhering to it. But obviously those standards are very expensive and onerous to comply with. I know very few organizations in South Africa who are. I think to a certain extent, they're a little bit more sold for more than they're worth. Like if you actually look at something like ISO 27001, it's not the watertight checklist that people sometimes make it out to be. It's very principle-based, very open-ended. It's not that different from GDPR, POPIA in many ways. No. So you think so go for it.
I know, and you see people turning the controls off after the auditors have left. So,
Exactly. You know, we've got our clean bill of health. We can go back to eating junk food. You know, but it's yeah. So people, it's useful, but you know, don't kind of think that that's a golden bullet to solve everything. And you know, the next level down is where someone comes into your backyard and tells you how to do things, and that's really the little checklist that someone will tell you. You know, usually at that stage, if you can hand up your own comprehensive information security policy, it's an opportunity to say to them, like, look, you know, thanks for your audit or your checklist, whatever it's called. But you know, we put a lot of effort into our information security. Maybe we don't think all your questions are that appropriate. You know, so I've, for example, been involved in doing a lot of assessments for a certain multinational IT company, and they kind of have a one-size-fits-all data protection infosec assessment, right? Now that applies as much to someone who is doing sort of forensic auditing on breaches for them as it does to someone who's taking photographs at their events, right? Now, those are often obviously very different levels of data protection, and the checklist that applies to one shouldn't necessarily apply to another. Now they're so large that they really just say, sign it or no business for you. But you know, most businesses aren't kind of in that scenario. So I think a more realistic position is, if you're going to use a checklist, come up with sort of something that's a bit more open-ended. You know, you can't prescribe exactly what people do with certain things unless there's a very good reason. You know, maybe you're in some sort of highly regulated industry where there's special laws or things like that. Maybe you're in healthcare or financial services, or you're doing some sort of tax things that have special requirements. But you know, really what you're doing there is the document embodies what you think are appropriate and reasonable technical and organizational measures for what you do. And you know, for me, there's actually 4 subcategories built there. And if you look at ICO's website, their guide to InfoSec talks about this. But it's really, there's physical information security. So, you know, what you do with the hardware and equipment people can see, making sure you've got CCTV cameras and locked office doors and things like that. There's digital InfoSec. That's the stuff that most CISOs are intimately aware of, rather. It's all the blinky boxes. You throw enough money at that, you'll solve that to a certain extent. And that's your technical measures. Then you look at your organizational measures. We break those down into your operational InfoSec and your administrative InfoSec. So your operational InfoSec is what the powerless majority in your business do when it comes to InfoSec. That's making sure that everyone from your lowliest call center operator to your CEO knows what to do when a phishing email hits, knows, you know, not to leave confidential information lying around the office, you know, knows to shred things when they need to, all that sort of human stuff. And then your last aspect is your administrative information security, making sure your powerful minority know what's happening, your key decision makers. That's your policy, your cyber insurance and things like that. So I would rather take a policy that hits all those beats and kind of says, you know, make sure you're doing the right things in those categories, and gives you ideas of what we think the right things should be, and then calls on the processor to explain why what they're doing is correct. So then it's less of a checklist and more of a questionnaire to find out what they're actually doing. Because give someone a checklist, they're just going to check, you know, please pay us, you know, whether they've actually done it or not at the end of the day. You know, sure, maybe you can hold them liable if they were lying to you, but that's a fight for another day rather than solving the problem now. You know?
Yeah. And I think you need to know what your sort of red flags are as well in that case. So, I mean, there's certain stuff in the risk assessment that's not necessarily going to be a bad thing for you, depending on who you're dealing with. I mean, if you're dealing with massive amounts of financial data and account numbers in the system, then maybe a certain thing is a red flag. Whereas if you've just got a system housing birthdays for staff or something like that for sending a digital card, it might not be a deal breaker, not having 2-factor authentication or something like it.
And it all comes down to the fact that data protection laws at the end of the day are principle based, and they require a risk-based approach. It's not black and white as much as people want it to be.
Yeah, no, that risk-based approach is the most valuable thing, to spend time on the right stuff that you need to do there. So, I mean, David, what do you think are perhaps some of the other aspects, just as we start approaching a bit of a wrap up here, what do you think some of the other aspects that a CISO should be looking at from a legal point of view? Because, I mean, Part B is not necessarily in a vacuum on its own. I think a lot of people make the mistake of seeing that. But what would you say are perhaps some of the things that they should be looking out for?
Yeah, so, you know, I very much approach it from where I come from, and at the risk of giving you a list of paperwork you need to go out and get, I'd sort of like to rank it in the order of importance to make sure you've got these things, basically. And yes, a lot of them serve privacy law, whether it's Part B or GDPR, but they also help you with other things. And it really, in terms of getting bang for your buck, you want to start on the outside of the business and go in. So all your externally viewable things are where you want to start. So, if you're thinking about, if you're nowhere and you're thinking about looking at DPAs first, the first step you need to get to is your privacy policy or your privacy notice. That is your outward statement of how your business is handling personal data. If that's not right, that's the foundation in terms of your outward communication regarding this stuff. It sets the tone for how you handle things in your DPA and things like that. If that's missing, that's a problem. Then you need to do a lot of governance things. So making sure, okay, it's no good having a DPA if I don't have someone to nominate who's actually governing this relationship for me from a data protection point of view. So then you need to appoint be your information officer in South Africa or be your data protection officer in EU and under GDPR and things like that. And you need to make sure there's someone who the buck stops with when it comes to these sorts of things. Then you get to the exercise of doing your DPAs. So DPAs often come sort of around third position, but then you'll find they're like Russian nesting dolls. Once you open a DPA, you find you need a whole bunch more paperwork. So within the DPA, then you would have your InfoSec policies that often gets referred to there. It often also links to an incident response policy. So that's your plan of action for, when someone hacks your server at 3 a.m. on a Sunday and encrypts all your files, who do you call and, how do you deal with it? Do you report it to the regulator or not? All those sorts of things. And there's lots of associated things that might go along with that. If you're in things like if you come to your DPA and you're having a fight about who the controller and who the processor is, because everyone wants to be the processor, no one wants to be the controller because the controller has the lion's share responsibility, then you're going to need to do some work kind of mapping your activities, maybe doing a bit of a ROPA or a record of processing activities, sometimes even doing an impact assessment there to work out for that activity who the responsible party and the operator are. So you can spend your life kind of burying yourself in paperwork when it comes to these things. But I think it's important to know what each tool is, what its value is, and when to do it. It very much depends on your size. For some businesses, you'll just start with a privacy policy and then you'll sign everybody else's DPAs. And only once you get to a certain size will you then come up with your own DPA template and start getting everyone to sign that.
Yeah.
But,
I must say I deal a lot with that with some of my smaller clients that deal with the EU. They just use the DPAs that are given to them, and so far so good.
And that's fine. It helps just to know how to read a DPA and knowing, broadly speaking, what should be in it and what shouldn't be in it, and being able to flag when someone's put something unusual in it. Yeah,
very much so. So David, in closing, if you had to think of one quick win that a business could do to put in for security or privacy, what would you say it would be? What would your biggest quick win be?
My biggest quick win wouldn't even be drafting any of these documents or anything like that. It would be understanding what valuable information you hold and who helps you process it. Because if you don't know that sort of thing, then all this is for naught. You can surround yourself in a wall of paperwork. You can, limit your liability on every single score. If you don't know what you've got and how you're supposed to protect it, then that's kind of a waste of time. So, and I mean, that's really done formally in terms of law. They call it a record of processing activities. We call it at Michalsons mapping your activities, but it's really just understanding the story. What does my business do with personal data? And the way I like to work it out is, okay, I come to work tomorrow. What's the one thing that if I couldn't do it anymore, there'd be no point in me doing this job anymore? And what's the personal data involved in that? And that's the stuff you need to focus on. Yeah. And then build everything else around that.
Absolutely. Great. David, thank you so much for joining us on this. How do people get hold of you if they want to find out more from you guys?
Sure. Thanks, Ross. Yeah, you can visit us at michalsons.com, so www.michalsons.com, or come find me on LinkedIn and drop me a connection request. I post some things there sometimes.
Fantastic. David, thank you very much for joining us, and thank you to all our listeners. And I hope you had a great time hearing about privacy, and you can go forth and work on your DPAs, work on what you need for the privacy side, because that is an integral part of what we do. Folks, until next time, we will chat to you then. Thank you for joining us.